Good morning, everyone, and welcome. We're pleased to have you with us today. We have 3 cases on the morning docket. We will call them in the order in which they appear. Unless the court has entered an order granting additional time to argue, let me remind counsel that you have each side has a total of 15 minutes, and that applies whether there's one or multiple attorneys. In which case you'd have to share that 15 minutes. The appellant does have the right to reserve up to 5 minutes for rebuttal. So when you come to the podium after you've introduced yourself, please let us know how many minutes you would like to reserve, and we'll program the clock accordingly. Are there any announcements or introductions? Hearing none, please call the first case.
83 Freight LLC versus C4 Sourcing Solutions LLC et al.
Good morning.
Good morning. May it please the court, my name is Roland Baggett. I am counsel for the appellants in this matter, 83 Freight LLC, Capital City Construction LLC, and SureTech Insurance Company. I would like to reserve a minute and a half for rebuttal.
All right, thank you. If you don't mind, we'll just round it off to 2, and we'll make it work. But
Okay.
we'll grant you a 30 seconds.
Our wonderful system doesn't do half minutes.
Well, I guess that's my first error of the day then.
Oh, that's all right. Hopefully it'll be your last.
Agreed. This matter arises out of the construction of a 3-building apartment complex that was from upcycled shipping containers. And to give you a little bit of the procedural background, on July 8th, 2019, appellee C4 Sourcing Solutions filed a lien claiming that $206,905 was due to it from Capital City Construction as the prime contractor, and that lien was sworn to by C4. C4 filed its original verified complaint on July 26, 2019, just a few weeks later, and subsequently 83 Freight filed a counterclaim and affirmative defenses, answering affirmative defenses, and Capital City filed answering affirmative defenses on October 3rd, 2019. Throughout the process of the trial court, C4 subsequently amended twice. Neither amended complaint was verified, and then later on, determining that its claims were unviable, C4 non-suited all of its claims, and 83 Freight, pursuant to Rule 41, assumed the position of the plaintiff. C4 then asserted counterclaims and third-party claims that were materially different from those pled in the original complaint, first amended complaint, and second amended complaint. The appellants here filed them.
You say they were materially different, but weren't they still suing on a contract and suing on a bond?
Yes, there was the complaint was the third-party counterclaim. Third-party complaint did have a claim on contract and on the bond. However, the contract was not the email that was the 71 containers that had previously been sworn to 3 times. It was instead a $2.1 million proposal that was not part of the proceedings for the non-suit.
Well, the parties, I think, admit that a formal contract was not executed, but a proposal was submitted, and the parties performed mostly until their relationship fell apart pursuant to that proposal, didn't they?
No, I would disagree, Your Honor. There was a proposal that was submitted, but
well,
that wasn't...
Well, the proposal was submitted that will provide you with containers, and then they proceeded to provide them with containers.
That is correct, but it wasn't that was a proposal for the entire project that was not something that was finalized and solidified. And so there were orders that were made on an individual basis, and they were made by 83 Freight LLC, not Capital City Construction, because C4...
Well, isn't that disputed?
Yes.
Okay.
It is. That was one of the disputed issues of fact at trial. Yes. But the claims that were materially different also had a different amount of damages that were associated with them. And rather than saying that the contract was with Capital City Construction as a subcontractor, it said that C4 said, we don't know who our contract was with. It's either with Capital City or 83 Freight. And
The jury found that it was with Capital City.
correct. That is correct. And, but from the pleading standpoint, we had moved to dismiss. That motion was denied on the basis they hadn't met the requirements of Rule 8. And putting on notice exactly what the claims were on who you have the contract with, and things like that. And the jury ultimately did find that it was Capital City, not 83 Freight LLC. Some of these claims were tried before the jury in May of 2023. The jury returned a verdict in favor of C4, awarding $866,991 against Capital City for the breach of contract, and $142,785 against Capital City on the prompt pay claim. It did not award 83 Freight any damages on its claim against C4. And then in subsequent bench trial proceedings on the lien/bond claim, the trial judge awarded C4 $206,945 against 83 Freight and SureTech, along with prejudgment interest, attorney's fees, and costs. And the
Now,
first...
let me ask you this. One of your issues is that C4 grossly overestimated the amount of the lien. But I think their number was approximately $220,000 when they filed the lien. But the jury came back with, or excuse me, the trial judge came back with an award of $206,000. So how do we, based upon these facts, find a grossly overstatement of the amount of the lien?
So, Your Honor, the lien was $206,905, and that is the award that came from the trial court on it. And you'll see it in the brief where we've listed out the information that was part of the lien and the number of containers that were ordered and what they claimed, but then also there were deductions that were required to be made for things that weren't incorporated into the property and other expenses that were not properly included in the lien. And the lien itself would have had a maximum of approximately $110,000, so it was almost double the amount that was...
Now, why do you say 110? How do you come up with that figure?
That was by taking the information provided in the discovery related to what the costs were for the containers and the information that was in the statute and just putting it all together. There's a detailed calculation that we have in our brief. If you'd like, I can go through it number by number. But
No, I've seen it. I have to say I didn't understand it. I'll read it again, but I see the figure that they started out with. I see the figure the trial judge gave. I see the argument that it was grossly overstated, and I'm having a hard time figuring that out. But that's my problem.
That's one of the reasons why we have an assertion of error on this related to the trial court's determination as to the lien and the subsequent award on the lien. Going back to the damages that were awarded originally, though, on the contract claim against Capital City, those were almost 3 times the amount that C4 testified at trial its damages were. And it testified that its contract damages were $288,849. And the testimony tracked the jury instruction on damages for breach of contract claim, and you have number by number, and it wasn't just a round number of around $300,000. It was $288,849, and the jury came back with an award of $866,991, which was almost 3 times that. And there was no material evidence that supports the 3 times amount. There were no punitive damages, none of that was part of this suit. And the testimony itself would be binding upon C4 as to what its damages were, but the jury came back with almost 3 times that, and that verdict was shocking when it was announced. Everybody, I think, the C4's lawyers were even surprised by it. And with that, we moved for new trial. Motion for new trial was denied. We asked alternatively for remediature. That was denied. And we would suggest here that there isn't material evidence that supports that jury finding and award. And because of that, this court should reverse the trial court's findings. Or alternatively, you have the power under TCA 2010-102A to suggest remediature. And we would request that there be a reversal there. The next issue that I would like to address is judicial estoppel. And when is an oath an oath? 3 times C4 swore that the information in its lien, its original complaint, which was verified, and a deposition, that the allegations in the original complaint were true and correct. And then later on, when it went to change its tune to say that it was 171 containers with a different contract and different damages, that's something that the prior sworn statements should have been binding.
Well, didn't that representation in the first complaint, which said 71, didn't it attach an exhibit that said it was actually 171?
I don't think so, Your Honor. I think that the exhibit was an email. It was actually an excerpt from an email that said 71.
But that wasn't exhibited to the complaint?
Not that I recall,
Okay,
no.
all right. Okay.
It was subsequently part
But
of the proceedings.
The argument is that it was simply a typographical error. Admittedly, it was 2 or 3 times, but it was 71 versus 171.
Well, I don't believe it was a typographical error, Your Honor. I think that the information that was provided originally by C4 to its lawyers, who C4 subsequently blamed for the mistake, was the information that they believed at the time. And then when they figured out that they might be able to get more, they changed their tune. And so here, the court should go back and apply the doctrine of judicial estoppel and have it be that the prior sworn statements are binding on C4, and not allow the contradiction that was there.
Well, you claim it was error for the court to refuse to allow you to show the original complaint and the subsequent complaint up on the screen. But the court said you could question the party representative about those issues before the jury, and you didn't. Is that correct?
I don't recall whether or not I did at trial or not.
I'll take that as an admission.
Yes.
And so isn't that waived?
No, because we preserved the testimony on the proffer that we made.
But you were given the opportunity to challenge C4's party representative about these inconsistencies or statements under oath that have been changed, and you didn't.
Well, okay, Your Honor, well, what I would suggest here is that the examination with the second and third amended complaint was contradicted by those were all different pleadings, and we should have been allowed to do it. If it was waived, then, we asked for the proffer on the testimony. I guess the last issue that I want to try to address in the very short period of time that I have left is an issue of first impression, which is reviewed de novo, and whether or not C4 prosecuted its claim on the lien with effect as required by TCA 6611-126B5. And this is an issue where the court has not interpreted what the language with prosecute with effect means, but other courts have, and that is that it needs to be continuous and uninterrupted. My time is up here.
You can finish that thought.
Okay. Continuous and uninterrupted. And so the continuous and uninterrupted prosecution of the suit is such that it kind of makes sense, where once you have a statutory requirement that you've got to file with your lien on a particular amount of time, once you get rid of it and it's dismissed, which is what happened here when they non-suited, then there's no more claim. And that's exactly what happened here. The trial court found that the savings statute allows it to be rebrought within a year, even though there was no lien, no bond requirement at that point, and the case had not been prosecuted with effect. And what I would suggest here is that the trial court erred in allowing those claims to be rebrought as third-party complaint and counterclaim, because there had not been a prosecution of the suit on that particular claim with effect.
All right, thank you. We'll hear from you further on rebuttal. And we'll hear from C4 counsel now. Good morning.
Good morning, Your Honor, and may it please the court. Evan Rothy of Sims Funk in the Nashville Bar, appellate counsel for C4 Sourcing Solutions, the appellee in this case. C4 respectfully asks this court to affirm the judgment of the trial court in all respects and award C4 its fees incurred on appeal under the Prompt Pay Act. Now, boiled down, this seemingly complex construction case is relatively straightforward. A contractor agreed to purchase custom building materials. Design defects and delays attributable to the appellants drove up costs and created production issues. Then, the contractor, in bad faith, refused to pay amounts owed above the disputed amounts at the time. Behind all this is the principal of the appellant, Capital City Construction, Sean Bales, who at the time was also the principal owner and operator of the developer, 83 Freight LLC, both appellants in today's case. Now, as the court noted, appellants had their day in court. The jury heard 83 Freight's claim against C4 and C4's breach of contract claim against the appellants, and it determined that 83's Freight's claim lacked merit and that C4's breach of contract and Prompt Pay Act claims had merit. It awarded damages to C4 to the tune of $866,991.
How did the jury come up with that figure? And I don't want you to list every line item, but it's a huge discrepancy between the, 288 or whatever it was.
Your Honor, on that point, I would refer that argument that only $288,000 was asserted in damages is not accurate based on the whole record. So, referring to appellant's reply brief, they refer to a sliver of Mr. Henderson, the principal of C4's testimony, and he's explaining a chart that he created to outline some of the damages. Now, the standard before the court on remititure at this point, now that the trial court is affirmed as the 13th juror, is to search the record and see if there is no material evidence. Now, the quantum of damages is a question of fact that we entrust to the jury. And so they're to look for any economic or pecuniary losses that have been presented. And so, in addition to the $288,000 that Mr. Henderson, who's no lawyer and no damages expert, listed in his chart, they heard other evidence in addition, and we've listed that in our brief, and appellants have not responded to those issues, those additional pecuniary losses in their reply brief. Some of those include, because the design errors created issues in the actual structure of the containers, there was forced refabrication, there was additional steel purchases needed. There were design defects related to the finish of the containers, so there was forced sanding of the materials, primer that was needed. The delays in permitting caused by appellants forced storage costs that were not anticipated, travel back and forth, transfer from one factory in China to another and we list several in our brief, and I won't go through all of them, but there are several instances of economic and pecuniary losses outside of the chart cited by Mr. Henderson that he created that support the quantum of damages.
But
I'm sorry, go ahead.
Well, I was going to say some of the damages, though, that Mr. Henderson put in his initial chart were included in some of this additional damage evidence. Is that not the case? I mean, for example, the storage cost was in the Henderson chart for having to store these containers that were not getting used, and crane costs, for instance, to move the storage container into into a storage situation. That was also included in some of these additional numbers. Is that correct, or were those separate?
Your Honor, I agree in part. There is some overlap between those additional issues, and certainly, this was a fluid situation, and so the contract is not clearly defined, and so there's some issues there. But I would contend that not all of these other pecuniary losses, I'd note some of the transfer from one factory to another is not incorporated in the chart that Mr. Henderson created. And again, I'd re-emphasize that referring to that Meals XRL Meals v. Ford Motor Co., the standard is no material evidence. And so if there's an iota of material evidence in the record that could support the quantum of damages, this court should affirm and certainly should not adopt the extraordinarily high standard of taking on remediature itself when the trial court declined to do so. Now, I'd like to turn to the lien arguments that opposing counsel raised this morning. Particularly, opposing counsel focused in on two arguments raised in their brief. The first that the court keyed in on was that the lien was grossly and willfully exaggerated. So under Tennessee Code Annotated 6611-139, a trial court has the discretion to bar recovery on the lien claim if it finds that there is willful and gross exaggeration. Now, as an initial matter, appellant's math is incorrect. So looking to the evidence in the record, we know that Capital City Construction did not pay for 9 supplied containers at $12,515 a unit. So that totals $112,635. And that's found in stipulations 20 through 22 in Exhibit 1 and Exhibit 46 for that amount per the unit. We also know that C4 specially produced 8 additional units at a cost of $100,120, and that can be found in Exhibits 52 and 62 of the record. Now, these specially created containers are furnished under the lien statute, specifically Tennessee Code Annotated 6611-1014A, Romanet 3 and 4. So there's a difference between building materials, whether they're incorporated in, and specially produced custom building materials. Those are includable in the lien amounts under the lien statutes, and I'd reference the court to the citation I just gave. Now, putting those numbers together, we have at least $212,855 of lienable amounts at that point, at least. And the lien, as opposing counsel mentioned, is $206,905. So there's no overstatement, let alone gross exaggeration. And additionally, I'd point that there also must be willful exaggeration. And the Beacon 4 case that we cite in our brief is on point to this. Opposing counsel has not pointed to any evidence in the record that shows willful exaggeration of a lien. So frankly, this affirmative defense doesn't find support in the record, and the trial court did not abuse its discretion by declining to bar C4's recovery on the lien. And turning to the issue of first impression that appellants have raised, whether C4 prosecuted its lien with effect, respectfully, the statute that appellants rely on doesn't stand for the proposition that they assert. Start with the statute. Tennessee Code Annotated 6611-126-5B says that where a lien is enforced pursuant to this subdivision, the plaintiff shall, in case of failure to prosecute the suit with effect, pay the defendants all costs adjudged against the defendants and all damages defendants may sustain by the wrongful assertion of the lien. In other words, Section 126(5)(b) has nothing to do with grounds for dismissing a lien claim. It provides a remedy to a party that has liened property if a lien claim is dismissed for failure to prosecute. That did not occur in this case. There's no finding that C4 failed to prosecute the suit with effect. Now, as an independent ground to affirm the trial court on this point, in addition to the statute not providing the remedy that appellants assert, the suit was never terminated. Again, the lien statute speaks in terms of suits, not claims. And there's no argument that C4 did not prosecute the suit with effect. And referring to the procedural turmoil that appellants referenced, shortly before trial, C4 did elect to voluntarily dismiss its claims due to the preclusion of its ability to present certain damages evidence at trial. And during that hearing before the trial court, when that was announced, there was discussion of what happens next in the case. And 83 Freight asserted that they would continue with their counterclaims. And at that point, C4's counsel asserted that its claims would then become compulsory counterclaims and sought leave to assert those counterclaims. The court gave it less than 2 weeks to do so, and C4 sought leave to assert its counterclaims, at which point the court heard the opposing arguments of the parties and then proceeded with the case.
Had the lien already been bonded out, forgive my terminology?
Yes.
Before the non-suit?
Yes. 83 Freight, I believe, bonded off the lien through SureTech Insurance about 10 months into the case, which was prior to the non-suit and assertion of the counterclaims.
And do you think the prosecute with effect applies after the lien has been removed from the property?
Respectfully, Your Honor, I don't believe that this statutory section that appellants have relied on provides for a requirement that there can be no break in the case between the assertion of the claims or change in the claims. And again, the suit was...
What I'm getting at is I can see where the policy interest is that we don't want property held hostage by financial claims that have no merit. And if you do have a claim, then prosecute it with effect or with expediently. But once a surety company, an insurance company, has removed the lien from the real estate and put up a bond, do we still have that expediency issue? Again, it's a first impression concept, but to me, it's just a suit over money, not a lien on real estate.
Agreed, Your Honor. And the public policy concern about tying up property through that lien claim is not applicable when you do have that lien bonded off. There's significance to the lien being bonded off. The Travelers Insurance case that we cite in our brief discusses that to some extent with respect to the effect of bonding off a lien removes the challenge to the validity of the lien. But more to Your Honor's point, there's no concern that once the lien has been bonded off, it's essentially a derivative contract dispute within the contract dispute at that point. The question is whether these amounts that secure the lien, the contract price, the concern about tying up property through the savings statute no longer applies. Unless Your Honor's, I'm sorry.
The issue that the defendants raised, or plaintiffs, third-party defendants, counter defendants, raised about the judicial estoppel on the original complaint and the reverse complaint. Am I correct that the court specifically said, I'm not going to let you show the first complaint, but you can question C4's representative about these facts? And they didn't. Is that correct?
Your Honor, my understanding of the record is that C4 was not allowed to enter, appellants were not allowed to enter into evidence the prior complaints that had been filed by C4, but appellants were given the opportunity to cross-examine Mr. Henderson about the differences between those pleadings. And so while the documents themselves did not enter into the record, right, there is cross-examination and testimony about that. So my understanding is that there was discussion at trial as between these discrepancies highlighted by appellants.
So you believe they did question him and he gave his responses to explain?
That's my understanding of the record, is that there was cross-examination. I wasn't in the courtroom, so I don't have firsthand recollection, but my understanding is there was discussion. And I would note that my recollection of the cross-examination versus the proffer given by appellants do not address anything substantially different. There's nothing added. The core question that appellants raised, and again raised before this court, is the difference between the allegation that there was an agreement for 71 panels in the original pleading and the counterclaim that asserts that there was an agreement for 171 containers. Now, again, judicial estoppel does...
You said 71 panels?
Panels is the language used by the original attorneys with respect to the claim in this case. And I'd also point out that...
Were the panels supposed to refer to containers?
Yes, Your Honor, that was an error.
So that was so it wasn't just a numerical error. There was a terminology error, panels versus containers.
Yes, Your Honor.
I didn't pick up on that. All right, thank you.
And Your Honor mentioned during appellant's argument that the exhibits to those original pleadings accounted for 171 containers. And so if the court looks to Exhibit A to marked for identification purposes, trial exhibits 54 through 56, they include the email that my colleague on the other side mentioned. And that container, or that email, when you look at it, the subject line of the email references a deposit for another 100 containers, or remaining containers, I can't remember the exact language, and the body refers to 71 containers that had already been purchased. So this was a midstream email that the original attorneys for C4 asserted was the basis for the contract. Of course, we now know that there was a proposal. And without getting into too much detail, the law firm originally representing C4 closed months before trial, and C4 was forced to switch horses midstream.
Yeah, so, I mean, but what I get from your briefing, I know that you've put some explanation in there about the $866,991,000. But the long and short of it is that we can't, looking at this record, we really can't come to a precise number. You're just saying that there is material evidence here. Is that a fair characterization of what you're arguing? Or am I wrong about that? You can say that you can look at all these various damages and come to that precise number.
Your Honor, the former, that there is a lot of testimony of pecuniary losses. There's no damages expert that brought it all together. And so we entrust the quantum of damages.
Yeah, I mean, so what struck me about this, so yeah, I was fine when you started out with, well, this was a contract for 171 containers and the overall contract value was $2.1 million. And then you get down and you're saying, okay, well, here's how much was paid and was left unpaid. But then you talk about the various damages and you get all the way down to, and he had plane flights to China. So, you know, how much that is, how much, if that is actually part of the damages, we just don't have any way to know, do we?
May I answer? I
Yes,
see
please.
I'm out of time. Your Honor, respectfully, I disagree that the plane flights, the travel that was forced by appellant's delays is not included within the quantum of damages, because these are costs that were incurred as a result of material breaches by appellants.
Wait, and I'm not saying, I'm not suggesting that could not be included in the number. We just don't know one way or the other.
Yes, Your Honor. There's no
Okay.
clean way to tie the
Yeah.
numbers all together. As
I
far
can't
as,
put my pencil to this pad of paper and look at the damage number and say, oh, that's how I get to 866,991.
Not cleanly, Your Honor, but I would assert we entrust that determination when there is uncertainty to the jury.
But that happens with a jury trial all the time.
Yes, Your Honor.
Yeah.
And being out of time, C4 respectfully requests that this court affirm the judgment of the trial court and award its attorney's fees under the Prompt Pay Act due to the jury's finding of bad faith. Thank
All
you.
right. Thank you, Mr. Rothstein. Mr. Baggett, you've got 2 minutes for rebuttal.
We have three things I want to go over quickly. Judge Clement, you had asked about whether or not, after the lien is removed by the bond, does the prosecute with effect language still apply? And the answer is yes. The statute 6611-126-5B states where a lien is enforced pursuant to the subdivision 5, or after suit is commenced on a bond provided pursuant to 6611-124, 6611-136, or 6611-142, the plaintiff shall, in case of failure to prosecute the suit with effect, pay the defendant or defendants all costs.
Thank you. That helps. Appreciate it.
The second thing that I would like to address is how the jury came up with the $866,000. And there's no way to figure it out. It's just not there. And that is part of what the quandary is. It isn't even an exact multiple of 3. You can say, oh, they said there was 3 buildings and this is something that gets multiplied by 3. Or there isn't anything that's there, and there's no way to get to that number. And particularly if you apply the requirements of putting somebody on a breach of contract claim back into the position they would have been had the contract been fully performed, i.e. they get their lost profits and other things that go with it, but you still have to take into account the costs of goods and the cost for delivery in this case. You still can't get there. There's just no way to do it, and that's where the 288 comes in.
But an accurate summary of the contract, the value of the contract here is $2.1 million, is it not?
That is what the proposal said, Your Honor.
Yeah, had anybody, if everybody performed as expected, this contract would be worth $2.1 million.
There would have been $2.1 million of expenses paid by 83 Freight as the procurer of the containers, and then all of the expenses that were associated with that. If there had been 171 containers that were delivered and they were conforming, yes, there would have been $2.1 million of liability on it.
All right, thank you very much. Thank you both for your arguments, and we'll take this matter under advisement.
Thank you.